Hello and welcome to Drishti IAS News. My name is Neil, and the topic which we are going to discuss today, I hope, will act as a primer in how we should consume news as citizens in general and as aspirants in particular. Well, the news has been that there have been certain allegations against Mr. Sameer Wankhede, who is heading an CB investigation into a drug case. We will discuss the constitutional aspects related to those allegations. This is how we will proceed with the discussion. First, we will discuss the news, the various dimensions of that news. Then, the constitutional provisions that come into the equation of that news, the controversy and the allegations that have been raised, and then the scheduled caste quota eligibility and its relation to the question of religion, that is conversion, how the reservation benefits are given and how it is interlinked with the politics of religion. And are these rules discriminatory, as several people have alleged? And then we will try to reach a conclusion, and then you will have a question to think over the problem as well as to practice your answer writing on. Let's begin. Now, there have been allegations against Mr. Sameer Wankhede, and these allegations have included or have brought in his identity, his religious identity, especially since he was selected under reserved list on an SC quota. So there have been some questions raised because Hindu SCs who convert to Islam lose their SC status and are no longer eligible for the quota. So this has been the news. We will discuss each of these dimensions in detail. First of all, the constitutional provisions. Which article defines the scheduled caste in India? Now the word scheduled caste, why it is called scheduled caste? Because there was really a schedule in the 1935 GOI Act in which certain castes were mentioned on a schedule to which certain benefits were to be given to bring them at par with the general society, Now, that this scheduled caste term was retained in the Indian Constitution, and in Indian Constitution Article 341 provides the definition regarding scheduled caste, that the president, this is the first important part, the president may, with respect to any state or union territory, after consultation with the governor, if it is referring to a state, by public notification, and I have star marked the word public notification, I'll tell you why. So president, after consultation with governor, if it is referring to a state, specify the caste, races or tribes or parts or groups of those caste, races or tribes for the purposes of this constitution to be deemed as scheduled castes. So this is the definition in the Indian Constitution. Article 341 clause 1 provides this definition, that president with respect to any state notifies the status of scheduled caste. The parliament may by law include or exclude any caste from this list. So this is the constitutional provision. Now I was referring to a public notification. This was the public notification which was issued in 1950. The Constitution Scheduled Caste Order 1950 stated that no person professing a religion different from the Hindu or Sikh or Buddhist religion can be deemed to be a member of a scheduled caste. Now, initially it was only Hindu. Later on, there were amendments in 1956 and 1990 via which Sikhs and Buddhists respectively were added to this order. So only these three castes, Hindu, Sikhs and Buddhist, allow for a status of scheduled caste to be given, while Dalits among the Christians and Muslims remain excluded 70 years since this order has been passed. Now moving on further. After the constitutional provisions, let us know what has been the controversy. Controversy is that the individual under question, Mr. Wankhede, benefited for the reservation of SCs despite being a Muslim and hence ineligible for the quota. We just read the order, the constitutional order of 1950. It disallows Muslims and Christians from having the status of a scheduled caste. So it is alleged that he has misused this reservation because his father was an SC, converted to Islam before marrying Mr. Wankhede's mother, and the birth certificate records his father's name as Mr. Daud K. Wankhede, that is allegedly a Muslim identity. Now, Mr. Wankhede is a 2007-8 batch officer. He was selected in the Civil Services examination of 2007 and he was selected under SC quota, to which allegedly he was not entitled if he was a Muslim. Now, there is a DoPT circular in this regard, that is Department of Personnel and Training Circular of 1993. What it states? It says that if any government servant who was not qualified or eligible in terms of recruitment and has furnished false information or produced a false certificate should not be retained in the service, and if he or she has become a permanent government servant and the charges are proved, the government servant should be removed or dismissed. So, this is the circular. Now, importantly, all that information, all that allegations, all that political slugfest is not important from UPSC perspective or even from citizenry perspective. What is important, we are now discussing. Now, there is an intersection between the reservation benefits and the religion, because 15% quota has been specified for SCs in government jobs, but Hindu SCs who convert to Islam or Christianity, they lose their SC status and are not eligible for the quota. A person belonging to scheduled caste or scheduled tribe will continue to enjoy this status or reap benefits of this status if he or she marries a person of non-scheduled caste or scheduled tribe. Also, a convert or reconvert to Hinduism and Sikhism or Buddhism shall be accepted as member of scheduled caste if he has been received back and accepted as member of that community. So, only when the person converts to Islam or Christianity, his status of being a scheduled caste person is taken away, but if he or she reconverts back to Hinduism, Buddhism and Sikhism, this status is given back. And no such religion based bar applies for STs and OBCs. So, there can be Muslim OBCs, there can be Christian STs, but there can't be any Muslim and Christian SCs. So, that is the intersection, and that has been a bit problematic. That it has been said so by several bodies. It has been commented upon by the Supreme Court, and National Commission for Minorities has also taken a position on it. So, are these rules discriminatory? In 2004, the Center for Public Interest Litigation challenged the legality of the provision by which people professing and converting to religions other than Hinduism, Sikhism and Buddhism are deprived of reservation benefits. So, this has been questioned. In 2008, very importantly, a statutory body, that is National Commission on Minorities, concluded that there was a case for inclusion of Dalit Christians and Dalit Muslims in the SC category. In January 2020, even the Supreme Court agreed to examine a plea by NCDC. It is basically a group representing Dalit Christians to make the government's affirmative action programs religion neutral. That is why it alleged that the government reservation programs are not religion neutral, and the plea is still pending before Supreme Court. So, if we are considering that are the rules discriminatory, we have to take these arguments under consideration. Now, so what the conclusions we can reach? These conclusions are not that important, but since this is the context in which we discussed this case, let us have some conclusions regarding Mr. Wankhede, that certain clarity is needed before reaching any conclusion on his case. That is, whether his father was a Muslim when Mr. Sameer was issued his caste certificate, whether his father converted to Islam to marry and then reconverted, and if so, when, and also whether Sameer changed his religion to Hinduism just to receive an SC certificate. These questions will allow us to reach a conclusion regarding Mr. Wankhede's case. But more importantly for our discussion, the conclusion regarding the reservation policy and politics in India, we need to analyze it in context of the allegations that are these rules discriminatory. So, one thing, that the exclusion of Christians and Muslims in the Constitutional Order of 1950 has been called discriminatory and violative of Article 14. Remember what Article 14 reads? It says equality before law. That is, state shall not deny to any person equality before law or the equal protection of laws within the territory of India. It prohibits discrimination on the grounds of religion, caste, race, sex, or place of birth. So, it has been alleged that this constitutional order interferes with the manifestation or with Article 14. Now, in NCDC case which we discussed of 2020, the then Chief Justice of India, Mr. Bobde, he also observed that the social exclusion of Christians and Muslims from the scheduled caste is a pertinent issue that requires Supreme Court's consideration. Now, in the light of all this discussion, remember what the certain bodies have said. You have to remember what Supreme Court has observed. You have to remember there has been a PIL which has been taken under consideration by Supreme Court, and there has been a position by National Commission for Minorities. In the light of all this discussion and the recommendations by various bodies, the observations by various bodies, we have this question. The question is that critically analyze the issues related to intersection of religion and caste in reservation policy under Indian Constitution. Think over this question, practice your answer writing. We will see you in next episode.